Hi, my name is Eric Chen, and I'm a licensed attorney in Maryland and founder of Zen Legal Planning LLC. I realize that I've probably talked too much about legal concept and used a lot of legal jargons in my previous videos. So instead of doing that, I might as well um, try to tell you a few stories related to estate planning, or actually without estate planning. So many people put off their estate planning for a variety of reasons. Maybe they're having a hard time agreeing on who to name as guardians, or maybe they're just simply too busy, and we'll eventually get to it soon. Unfortunately, this can potentially have serious consequences. I'm going to share with one of the saddest stories of why it's important not to procrastinate on estate planning. In 2006, a couple from California and their three sons, ages 3, 5, and 8, were on vacation in Arizona when they got into a really bad car accident that killed both parents while the three boys survived. At that time, there was so much confusion as to who should care for their children, but because this had happened across state lines, there was also confusion as to which court had jurisdiction to decide the boys' future. Therefore, the three boys were placed into temporary custody of Child Protective Service while the courts tried to figure out who has custody of the children. When you think the situation is bad enough, it got worse. Since the couple had never legally documented who they wished to be guardians for their children, legal battle between sisters of the mom followed because they all came forward claiming they were the best for the children. Ultimately, over 1,000 pages of documents were filed. 9 lawyers were involved. Tens of thousands of dollars were spent trying to figure out who should be the guardians for the children. Some of the court documents indicated that the couple had talked to certain family members about naming guardians for their sons, but since nothing had ever been legally documented, there was no clear guidance for the judge. Although a legal guardian was eventually appointed after several years of legal battle, we would never know who the couple would have wanted to raise their children. All of this could have been avoided with simple estate planning that provides clear guidance according to their wishes. The good news is that it doesn't have to be this way. By taking the time to legally document your wishes for your children, God forbid, in the event anything happens, you can avoid this nightmare for your family. Next, I'm going to share a story about a widow. The widow's husband had suddenly died, and husband basically had a great income, a very nice home with a large mortgage, and a $1 million life insurance policy. Unfortunately, he didn't have a will, and the insurance proceeds had to go through probate process because he named his estate as primary beneficiary instead of his wife. So the court had to distribute according to interstate laws uh, by giving the wife, the widow, $500,000 and the child $500,000. But since the child hasn't turned 18 yet, so a guardian had to be appointed to manage the asset for the child. And in the meantime, the mom couldn't afford the mortgage, the bills, and private school. So she had to sell the home and get a low-paying job because she had been out of the workforce for more than 10 years. So eventually, when the child turned 18, which is the age of majority in his state, he received his $500,000 outright. What got worse is that the child went out and bought a fancy sports car, got into a car accident, and seriously injured another person due to his fault. And the injured person then sued the child and took away basically the entire inheritance. This problem could have been easily solved by ensuring that the beneficiary designation is changed to the spouse, or by setting up a trust and naming trust as contingent beneficiary in order to regulate distribution of assets based on needs. When considering beneficiary designations, be especially careful of the contingent beneficiary. The contingent beneficiary is the beneficiary who steps up if the primary beneficiary passed away before you. We often find that contingent beneficiary is left blank. In such cases, it's assumed that the contingent beneficiary is your estate, meaning the assets will pass to your heirs through the probate process. And if there is no will, that means according to the intestate laws of your state or of residence. Also, you want to be mindful of joint title to real estate, because if the joint title holder predeceases you or passes away before you, then the real estate will also pass through probate at your death. Last, I will share another story about a same-sex couple. This couple was legally married in a state that recognizes same-sex marriage. When they thought they were in good shape in terms of property distribution without will, they moved to a different state that doesn't recognize same-sex marriage. At that time, they knew they had to have an estate plan in order to safeguard their future. What they didn't expect was that one of them would die in a car accident before they executed a will. In a state that doesn't recognize same-sex marriage, the surviving partner got nothing. Instead, it was the estranged parent of the deceased partner that got all of the assets based on intestate law of the state. If they had executed a will instead of relying on intestate law, the problem would have been avoided. Based on those stories, what's the one thing that concerns you the most for not having a plan? Or are you happy with the no plan or estate plan approach? Feel free to comment below to share your concerns or opinion. I wish I could make it a little bit more interesting, but you know, these stories are just sad, and hopefully we'll share some of the positives for having an estate plan and problems solved by having proper documents in place. Thanks for watching this video.